records from the White House were made public 12 days before the hearing. With Judge Kavanaugh, we have 7%, and only 4% are public. You can talk about the numbers of pages. The fact is, 99% for Elena Kagan, 12 days before the hearing. It was all available. For Judge Kavanaugh, 7%, and only 4% made public. So, if we're going to argue what was precedent, I would point out that I've been in the Senate for 19 Supreme Court nominations. What is being done here is unprecedented. And I keep coming back to the same question I asked. What are we trying to hide? What are we hiding? What's being hidden? Why not have it open like all others? The only other time we heard a president invoke executive privilege was President Reagan during the Justice William Rehnquist hearing, and Republicans and Democrats together went to him and said, "Don't do that." He said, "Okay, you're right." And he withdrew his request of executive privilege and released the documents.
Mr. Chairman,
I'm just sorry to see the Senate Judiciary Committee descend this way. I felt privileged to serve here under both Republican and Democratic leadership for over 40 years. This is not the Senate Judiciary Committee I saw when I came to the U.S. Senate.
Mr. Chairman, my name was invoked by you. Could I please respond?
After I get done, I want to give the exact quote that I was paraphrasing. Chairman Leahy said, quote, "We have Judge Sotomayor's record from the federal bench. That is a public record that we had even before she was designated by the president. Judge Sotomayor's mainstream record of judicial restraint and modesty is the best indication of her judicial philosophy. We do not have to imagine what kind of a judge she will be because we see what kind of a judge she has been." And so that's why my answer to the gold standard of whether Senator Kavanaugh ought to be on the Supreme Court, based upon what Democrats themselves have said is the best judge of whether you should be on the Supreme Court, Senator Klobuchar.
Oh, wait a minute. You mentioned what I said. Let me just finish on that. On Justice Sotomayor, I did say that we should look at her cases just as we should on Judge Kavanaugh. But you neglect to mention, carefully neglect to mention, and I think erroneously neglect to mention, that the Republicans asked for board minutes from her work at a civil rights group in the 1980s, long before she was ever even considered as a judge. You asked for that, and we got it for you. That's
Mr. Chairman.
Mr. Chairman.
Mr. Chairman, you called on me.
Before Senator Klobuchar speaks, we have 488,000 pages of documents. Go ahead, Senator Klobuchar.
Thank you very much, Mr. Chairman. A few points here. Number one, Justice Sotomayor never worked in the White House, so none of these issues of executive privilege or other things that we've been discussing are relevant. Number two, while I appreciate you granting my request, Mr. Chairman, on these campaign finance documents, this is all they were. This is it. This is how many pages. Yet we have 148,000 documents that we can't talk about publicly. And I will say they are illuminating. It shows that the nominee has a limited view of campaign finance reform. In his own words, he says that his views on the First Amendment are pure when it comes to this very important issue. And we can talk about that more in the future. But I do have a question, and that is that, yes, I asked for these documents, but I've also joined several letters led by Senator Feinstein asking that all the documents that we have in the committee be made public so that we can ask questions. And then finally, on my initial point that I'm so focused on, the 102,000 pages of documents from Judge Kavanaugh's work in the White House Counsel. I would like to know, Mr. Chairman, if you have another example of a time when executive privilege was invoked to block the release of presidential records to the Senate during a Supreme Court nomination. As far as my research shows, this wasn't done for Justice Kagan or Justice Roberts, and I'd like to know if you have another example of that during a Supreme Court nomination hearing.
Yeah, it was done for Justice Roberts, and it was the Solicitor General position he had.
When he was a Solicitor General, that is correct, but during the time that they worked in the White House. That is my question.
Mr. Chairman, I'd like to bring to the attention of the chair.
I believe I have the floor, Mr. Chairman. Thank you, Mr. Chairman, for recognizing me. I haven't been in as many confirmation hearings as some of my colleagues, but this is the first confirmation hearing for a Supreme Court justice I've seen, basically, according to mob rule. We have rules in the Senate. We have norms for decorum. Everybody, as you point out, Mr. Chairman, is going to get a chance to have their say. You've given everybody a chance to ask questions for up to 50 minutes. You've given them a chance to make an opening statement. Any one of our colleagues can step out here and talk to the press and make whatever comments they want to the press and tell the world how they feel about this. But the fact is, it's hard to take it seriously when every single one of our colleagues in the Senate Judiciary Committee on the Democratic side have announced their opposition to this nominee even before today's hearing. So it's hard to take seriously their claim that somehow they can't do their job because they've been denied access to attorney-client or executive privilege documents when they've already made up their mind before the hearing. There's nothing fair about that. And we would just ask for an opportunity for the American people to be able to listen to this nominee answer the questions that we have. And I think that's how we ought to proceed, and I hope we will.
Mr. Chairman, can I be recognized to respond specifically to that comment? There is precedent here. There are rules that can guide us. We're asking for those rules to be followed. In the past, our colleagues on the Republican side have asked for a postponement of these committee proceedings on nominations when documents have been denied on 2 occasions from Senator Sessions, then Senator Sessions, and Senator Kyle. Those requests were granted. We're asking simply that that precedent be followed, Mr. Chairman. Far from mob rule, far from contempt of the process, we're simply asking for respect here to the normal, regular order.
Mr. Chairman.
Go ahead.
Mr. Chairman, I'd like to address this committee confidential issue one more time because you've explained your point of view. Here's what we know. The Chairman Grassley, who's my friend and I respect, said his reason for unilaterally designating 147,000 pages of Burke documents as committee confidential is because that was the condition that Bill Burke imposed on the provision of the documents. When Judge Kavanaugh was in my office, meeting with us, I asked him, who is Bill Burke? By what authority can he restrict the information given to the Senate Judiciary Committee and to the American people? Is he a government employee? No one knew this mysterious Bill Burke who was filtering these documents. So I figured since the nominee carries the Constitution in his pocket, there must be some reference to Bill Burke in Article 2, Section 2, but it just says advice and consent of the Senate. It doesn't include Mr. Burke. By what authority is this man holding back hundreds of thousands of documents from the American people? Who is he? Who's paying him? So committee confidential is being determined by a man, a private attorney, and we don't know who he works for or who he's accountable to. Mr. Chairman, in the past, when we went into committee confidential, it was in a discrete, specific area of concern involving a handful of words or accusations that had been made in a document, and we were very careful to do it on a bipartisan basis. That has not been the case here, where 147,000 pages have been designated by Bill Burke as outside the reach of the American people in the Senate Judiciary Committee. That's a further example of why this whole process has gone astray, and I think your explanation ignores that.
Mr. Chairman. Mr. Chairman.
Who wants the floor?
The new senator.
Go ahead.
Thank you, Mr. Chairman. Mr. Chairman, can you tell me again how many documents have been produced?
488,000 minus, other than 28,000 pages that Justice Kavanaugh has submitted, including his own judicial opinions.
Number two, are we in executive session or not?
We're having a hearing on the nomination of a nominee for the Supreme Court.
Yes, sir, I
We're
got it.
not in executive session.
All right. Number three, at some point, are we going to get to hear from the nominee?
Hopefully, it was going to be before 2:30. It'll probably be later this afternoon now.
All right. Thank you, Mr. Chairman.
Yeah.
Mr. Chairman.
Can I ask my colleagues on the other side of the aisle how long you want to go on with this? Because I'm not going to entertain any of the motions you're making. We're not in an executive session, and I think we ought to level with the American people. Do you want this to go on all day? Because I have been patient. I've been accused of having a mob rule session. Now, if we have a mob rule session, it's because the chairman's not running the committee properly. But since every one of you on that side of the aisle, except Senator Booker, Senator Harris, new to the committee, said during Justice Gorsuch's hearing, every one of you prefaced your comments on how fair I was in running that hearing. Now, this is the same Chuck Grassley that ran the Gorsuch hearing. I'd like to run this hearing the same way if you'll give me the courtesy of doing it.
Thank you, Mr.
How long do you want to go on?
Mr. Chairman, I'd like to make one more point before we proceed, if I might.
Senator Cool.
The accusation that this is a mob rule hearing was made by your colleague from the state of Texas. I think you have been conducting this in a respectful, appropriate, and deliberate way. My concerns that I want to renew, given the exchange you just had with Senator Leahy, who has participated in or presided over more Supreme Court confirmations than any currently serving member, I believe, was over how the document request was handled for now Justice Kagan. A request was sent to the National Archives. Ranking Member Feinstein tried to work with you to send an identical request to the National Archives. And before we proceed with the questioning, Mr. Chairman, I simply would like to have a settled heart about why you chose to communicate directly to the archives, not to respond to the ranking member's request. Members of this committee have raised issues about an unprecedented committee process by which documents were blocked, by which they were considered classified, and by which we have been blocked from being able to share them with the American people or ask questions based on them. This is unprecedented. That's why, as you put it, this side seeks to raise issues to establish ground rules before we proceed.
You asked an appropriate question. I have an answer. I don't know whether it will satisfy you or not. Those documents are the least useful in understanding his legal views and the most sensitive to the executive branch. And let me emphasize the most sensitive to the executive branch. The staff secretary serves as an inbox and outbox to the Oval Office. And if you're going to have opportunities to ask the nominee himself what he did then, but I'm giving you my judgment about being a person that primarily was responsible for managing the paper that crosses the president's desk. His job, and if I'm wrong, he can satisfy you otherwise in your questions you want to ask him, but his job was to make sure the president sees the advice of other advisors, not as staff secretary providing his own advice. One of President Clinton's staff secretaries, Todd Stern, described the job this way. I quote, "The staff secretary's job is not to influence the president, but to ensure he gets a balanced diet of viewpoints from all relevant people on the staff. You're certainly not trying to put your thumb on the scale between options." Reviewing Judge Kavanaugh's staff secretary documents would teach us nothing about his legal views. For that, we have the 307 opinions that he wrote and the hundreds more joined, totaling more than 10,000 pages of judicial writings. We also have more than 17,000 pages of speeches, articles, teaching materials, and other materials that Judge Kavanaugh attached to his 120-page written response, which I think was a judiciary's questionnaire, was probably the most robust questionnaire ever submitted to a Supreme Court nominee. We also have